Hello and welcome to another Wednesday evening of How to Write a Tax Efficient Will with me, Deborah Bowers. Today, we shall be discussing how to revoke a lasting power of attorney. We know that many people are always worried about having granted a lasting power of attorney, how they will be able to revoke it. But before we get started, let me introduce myself. I am Deborah Bowers, a STEP certified advanced will writer, a solicitor of England and Wales, and a GDPR practitioner qualified in CIPPE and CIPM. I am also the author of How to Write a Tax Efficient Will, which is here on the screen. I've got to give you a disclaimer at this point. Nothing that we discuss during these sessions is to be considered to be financial advice or legal advice or tax advice or investment advice. This is a general discussion and it will not create a client-solicitor relationship between me and you. If you wish to make decisions based on what has been discussed, I encourage you to carry out your own due diligence and do your own research. Sometimes I point out where you can or get some more information, and you are welcome to do so. Some of those sites are government websites. Alternatively, you can discuss it with a solicitor or a will writer. Now, in our last session, which took place on the 2nd of November, we discussed what a lasting power of attorney actually is. And during that session, we came to the conclusion of exactly who needs a lasting power of attorney. We discussed that. We looked into, was it this elderly couple or was it this young man? Because they look older, is it the case that they need one? Or because he's young, is that why he doesn't need one? And during the course of our discussions, we came to the conclusion that everyone needs a lasting powers of attorney because neither the old couple nor the young man who was the picture of health, neither is exempt from finding themselves at the hospital, able to do nothing and needing someone to assist them with their financial decisions or health and care decisions. So having already dealt with that in our webinar of the 2nd of November, if you missed it, please go on to my YouTube channel, it's Deborah Bowers channel or at Deborah Bowers, and you will find it there. It was a rather interesting and exciting webinar because I was able to catch a few of you out by demonstrating that everyone needs a lasting power of attorney. We shall now move on to discussing some of the worries that people have. So once they have already put in place a lasting power of attorney, they wonder, will I be able to revoke it? Can it be used to change my will? What if I appointed my partner and we got divorced? What happens if my attorney loses mental capacity? Can I remove an attorney who has been appointed? Or can I add an attorney? And these are some of the things that we shall be discussing in this session, just to allay anyone's concerns and fears in this regard, because these are things which worry quite a few people. So how do you end a lasting power of attorney? Remember, we've discussed that once you have mental capacity, the key is mental capacity. You can end your lasting power of attorney yourself once you have mental capacity to make that decision. And you will need to send the Office of the Public Guardian both the original lasting power of attorney and a written statement called a deed of revocation. So we have here what a deed of revocation would look like or what it would state when you send it to the Office of the Public Guardian. It is called a deed because it requires witnesses or witness at least to sign. and indicate that they've seen you make that decision and they are aware that you have made that decision. So you can word it as follows. This deed of revocation is made by, of course, you put your name and your address, and you made it for welfare. You delete as appropriate, on what date that you made it or signed the lasting power of attorney, and the name of the person you appointed with their address. The first person, the second person, or as many people as you appointed to act as your attorneys. And you indicate, I revoked the lasting power of attorney and the authority granted by it, and signed and delivered as a deed. You place your signature, the date you've signed, and the witness also signs the signature of the witness, the full name, and the address of the witness. Just in case it is challenged, if anyone wants to confirm whether or not you actually did revoke the deed, the lasting power of attorney, then we can go back and check with that person who saw you sign and was present when you created that deed of revocation. Another question people always have is, how can I remove an appointed attorney? So you've already appointed someone and then you fall out with that person, or that you no longer wish to have that person representing you as one of your attorneys, you no longer feel comfortable with them. You prepare what is called a partial deed of revocation. And this is something that you can do. So the partial deed of revocation would state, this partial deed of revocation is made by, of course, you are the donor, the person who actually granted the lasting power of attorney. You state your address, and then you state 1, I granted a lasting power of attorney for property and financial affairs, or whether it was for health and welfare. You delete which one or you include which one is appropriate. And on the date, you signed the lasting power of attorney, and you appointed, you named the person, you put their address and the name of the second attorney and their address to act as your attorneys. And on this occasion, you say, I hereby revoke, and you give the attorney's name that you would like revoked. So you no longer like this person in particular to act on your behalf. Only from the lasting power of attorney and the authority granted to him. So only for that purpose, you want that person's name revoked. And you sign also as a deed, you date it, and it's witness, you state your witness then signs, puts their full name and address. So once again, you need to execute what is called a deed, but this time it's a partial deed of revocation. So the first document we saw was a full deed of revocation, where you just wanted to revoke your lasting power of attorney completely. But this time you have already appointed the attorneys and you want to remove one of those people whom you appointed. And this is how you would do it. Now, what is also very important is to understand the difference between removing an attorney and adding an attorney. I find that most people become very confused by that. In the case of removing an attorney, the attorney must have already been appointed. So we see 4 people here sat at the table. Let's say they are your 4 attorneys. Or there might be 5 people there if I count the heads. But if you wanted to remove one of them, they could simply leave the table and they would be removed. But when it comes to adding an attorney, this is where you have difficulty. And let's see how you, if at all, you're allowed to add attorneys that you have not already appointed. So when it comes to removing an attorney, that person must be someone who's already been appointed. That's why you can remove them. So we must remember that crucial difference. And adding an attorney. If your desire is to add an attorney, then you must end or revoke your lasting power of attorney and appoint new attorneys. It is as simple as that. There isn't an option to add people on once you have already created the lasting power of attorney. Of course, you must always have mental capacity. So once you have mental capacity, you are able to decide, I want to add someone, but now because I really wanted that person, the first thing you have to do is to revoke what you've already done and create a new one. Because you can't add people on at a later stage. There are other ways in which a lasting power of attorney can be revoked. And some of those ways are your attorney loses the ability to make decisions or loses mental capacity. So just as it depends on you having capacity to actually have a lasting power to act and either grant a lasting power of attorney or revoke a lasting power of attorney. If your attorney loses capacity, then your attorney will automatically not be able to act on your behalf. So in such circumstances, the lasting power of attorney or the power granted to that person comes to an end. Also, you must simply inform the Office of the Public Guardian that this person has lost capacity, they can no longer act on your behalf. Another way that a lasting power of attorney can end in relation to a particular person is because they have divorced you or they've ended a civil partnership if they were your husband or wife or your partner. So if you are no longer in a relationship with that person, then that person cannot act on your behalf. You are divorced from them or the civil partnership you were in has ended. And so that causes your lasting power of attorney to come to an end. Also, another way is if someone becomes a bankrupt or they're subject to a debt relief order, they're a property, if they are a property and financial affairs attorney, if you appointed them to deal with your property and financial affairs, then if they become subject to a debt relief order, then that appointment will end. Simply because you cannot have someone who's in need of finances dealing with your finances because they might be tempted to use your finances to solve their problems. So if that becomes the case, that appointment will end. A lasting power of attorney can also come to an end if the person is removed by the court of protection. So the court of protection might decide that a certain person needs to be removed from being an attorney and bring a lasting power of attorney to an end. Another way is whether or not a person dies. If your attorney dies before you, then of course that person can no longer act on your behalf, and that will also bring the lasting power of attorney or the power granted to that person to an end. So there are quite a few ways that a lasting power of attorney can come to an end. So in this session tonight, I want to encourage everyone, all of you, to take care of each other, make sure your documents are in place, and that you do what you can or what is necessary to look after the welfare of each other. We know that you will need a will in your lifetime to look after yourself properly. You need lasting powers of attorney in case you find yourself hospitalized and you can't make decisions in relation to your finances. or your health and welfare, your care, because no one is exempt from being sick in hospital and not being able to take care of their affairs. Also tonight, my course is available. It's on a 50% discount. It's only £48.50. So if you wish to purchase it, please do so. Once you have purchased it, I'm also going to send you a signed copy of my book, How to Write a Tax Efficient Will. So feel free to take advantage of the course being at the price that it is right now. It will not remain at that price forever. It is £97, and it's actually on a very special offer tonight. Here is the website where you can find the course. It's https://bowersdeborah.mastermind.com/mastermind36966.